Owning French assets while living and dying outside France creates a collision of systems: succession law, matrimonial property, real estate formalities, and tax timelines. When rules are misunderstood, heirs are pushed into urgent filings, freezing measures, and partition lawsuits. This video shows how disputes arise and how to anticipate them. Before fighting about shares, courts want to know which law and which forum govern the estate. Heirs can end up in different courts at once because death abroad often triggers parallel tracks. A foreign probate for worldwide estate issues and French proceedings for local assets, notably real estate. If heirs disagree on forum or timing, one of them may race to a French judge to secure interim measures over the asset. As a principle, the law of the deceased's habitual residence will steer the succession, but many expatriates sign a choice of law clause, professio juris, favoring the law of their nationality. If there is no clear choice, or if the choice clashes with French mandatory rules, disputes over shares and powers can escalate quickly. Before calculating heirs' portions, French practice separates the spouse's property, matrimonial regime, from the estate. A mismatch between a foreign marital agreement and French conflict rules can force heirs into court to characterize assets, community versus separate, before any distribution. Land in France is transferred on paper only when formalities and consents align. The answer is no. French real estate changes hands via a French notarial deed after title checks and publication at the land registry. If one heir refuses to sign, the others cannot bypass them with a foreign grant. They must seek a court-ordered partition and sale, or a judicial appointment of a representative. French law protects reserved shares for descendants. Lifetime gifts or friendly discounts to one child may be clawed back, reduction. If relatives disagree about the valuation or the nature of past transfers, gift versus sale, litigation over reconstitution of the estate is common. Co-heirs own the asset in indivision. Persistent blockage often ends in licitation, judicial auction, or an order appointing an indivision representative. An occupying heir may owe an occupation indemnity, which itself becomes a point of dispute. The first mover can shape the case through urgent measures and documentation. Heirs fearing concealment or dissipation may seek sealing of premises, an inventory, or protective orders on bank accounts. These measures, often granted ex parte or in summary proceedings, quickly set a litigation trajectory if cooperation fails. French judges decide from the file. Missing marriage contracts, untranslated wills, and incomplete bank records allow opponents to argue that shares or powers are unproven. A thin or inconsistent file pushes parties into court to obtain judicial expertise and production orders. Disputes over acceptance versus renunciation of the estate, challenges to gifts or wills, or claims for reimbursement all carry deadlines. Mismanaging them provokes defensive lawsuits to interrupt limitation and escalates costs for everyone. Please keep in mind that a few upstream decisions save years of co-heir warfare. If you want to prevent forum and law fights, sign a clear choice of law clause consistent with your family goals and align it with your marital regime. Where French forced heirship might bite, design lifetime arrangements, for example, balanced gifts, usufruct/naked ownership splits that will be defendable later. Retain a French notaire alongside foreign counsel, build a complete inventory, real estate, accounts, insurance, and agree a written timetable for valuations and decisions. If one heir resists, propose mediation with a tight calendar before anyone files. When a co-heir blocks access, hides assets, or refuses basic steps, swift summary proceedings for inventory access or appointment of a representative de-risk the file and often bring parties back to the table. Knowing this option exists prevents endless stalemates. Heirs land in court when forum, law, title formalities, and family expectations collide. Prevent it by choosing applicable law, aligning the marital regime, preparing a documented inventory, and engaging a French notaire early. If cooperation fails, targeted protective orders and partition tools exist. Use them to impose a structured timetable instead of drifting into years of conflict.